counsel at time of arrest, which is what Mr. Shaw's counsel requested initially, or at the time Mr. Shaw or the defendant is requested to submit to a breathalyzer test. The rule requiring that counsel attach at that point would make it impossible for the people in driving while intoxicated cases, for the police in driving while intoxicated cases, to gather evidence of driving while intoxicated situations. In other words, to gather evidence with respect to that particular defendant's blood alcohol content. And as His Honor has just pointed out, what if counsel, these cases normally involve arrests which are made sometime after 12 midnight. What if counsel is not attainable at that time? Obviously, if the right to counsel attaches, it cannot be withdrawn after 2 hours. And what counsel is asking this court to do is to legislate that as part of either a state constitutional right or with respect to some sort of federal right, that a defendant be allowed to ask for counsel up until the 2 hours is about to expire, and if none can be found, then at that point, the defendant would have to submit to the chemical test or refuse to submit to the chemical test. In driving while intoxicated situations, as this court has held in Walter and Daniel and Moselle, unless there is a death or serious physical injury, the prosecution cannot force the defendant to submit to a chemical test. So absent those special circumstances, if counsel is to attach at the time the person is arrested or at the time the person is requested to submit to a chemical test, and no counsel can be found, or for that matter, if counsel is found, the people have no recourse, they cannot give a test. So basically, the people are asking that counsel's requests to establish a new rule in this situation not be found to have merit in this particular case, and the people will rely upon our brief as to all the other points that counsel has raised. Thank you.
Thank you very much, Mr. Trace. People versus Gensler. This is basically, under the statute, a discretionary call by the trial judge with respect to whether or not to have a psychiatric examination. Is it not, Ms. Lee?
No, Your Honor. When Mr. Gensler was found to be incompetent by Mid-Hudson and returned to the trial court judge, or to the trial court, I'm relying on the Second Circuit's case of Silverstein versus Henderson that said that the trial court must follow...
That's interpreting our statute.
Right.
They didn't say it's a constitutional obligation.
No, they were interpreting our statute. Right.
Who can do that better? The Second Circuit or the New York State Court of Appeals?
Well, Your Honor, if I may say that...
Wait a minute, I want to write your answer down.
I feel that the Court of Appeals hasn't yet decided precisely what the court should do, or has not spelled out what the court should do when the defendant is brought back from Mid-Hudson. In particular, in regard to how many reports are required, and as to whether or not, if there's a short period of time between the reports from the local psychiatrist and the report from Mid-Hudson, as to whether or not that constitutes a conflicting report and requires a hearing under 730.30 subdivision 4. So,
But you would say, under the facts of this case, it's really a per se rule that the trial judge has no discretion.
well, if I may point out, in Silverstein, what they said was there must be 2 reports from Mid-Hudson saying he's competent. That if Mid-Hudson sends him back, which is what they did here and what they did in Silverstein, with 1 report saying that he's competent, that's not enough, that they must have 2. And that further, when the report comes only 2 weeks after the local psychiatrist found him to be competent, and in this case it was only 3 weeks, that constitutes a conflicting report, said Silverstein. And it requires a hearing, that it is not in the court's discretion anymore when it's only 3 weeks. I'd like to point out that the Silverstein case pointed out in a footnote that if there were 5 months, for example, between the reports from Mid-Hudson and the local psychiatrist, a hearing would not necessarily be required. The Fifth Circuit found that to be true.
We know those footnotes don't mean anything, though, don't we?
Well, they were using it as an example.
As an example to counterpoint their effort to amend the New York CPL? Because what they did, didn't they, is add something that is not in the statute in terms of the ritual that the trial court is required to carry out.
But Nana, I feel it's very much in the statute. In fact, I read your commentary where
I'm
you
not
said,
bound by those anymore.
where you said, when the person is brought back to the court, the amendment, 730.30 subdivision 2 was amended, 730.60 was amended that the court was to follow 730.30 subdivision 2, and that the purpose of the amendment was for the court to determine competency when he's brought back under section 730, section 730.30.
So this court has the psychiatric report from Mid-Hudson.
Right, one
or the-
report.
The report from several other psychiatrists saying this man is perfectly rational, except those times when he didn't take his medication.
No, the other psychiatrists found him to be incompetent. In fact, at first they found him to be competent, the court-appointed psychiatrist, and I never believed he was competent. Then I got the records of this man from Marcy, where he'd been admitted 4 times, and curiously enough, one of the reports from Marcy was from one of the court-appointed psychiatrists who himself had committed Mr. Gensler a few years before under 2 psychiatrist commitment. So when that doctor read his earlier report, he said, oh, yes, this man is incompetent. And they found him to be incompetent. And this was also brought out by Dr. Weber, the defense psychiatrist that I had hired to try to look into this matter. And reading Dr. Weber's reports, and then again seeing him at the jail, these 2 doctors found him to be incompetent. And then he spent 6 days at Mid-Hudson. The appellate division said he was given medication at Mid-Hudson, which is true, and then returned to county court, and he had a demeanor of competency in court. But the point is that...
When he came back after 6 days, there was 1 report or 2 reports?
1 from Mid-Hudson, Dr. Vandenberg.
And was that conflicting with any prior report?
Right, Dr. Vandenberg said he was competent. Dr. Rao and Dr. Cotwell, the 2 court-appointed psychiatrists, said he was incompetent, and so had Dr. Weber, the defense psychiatrist. But what I wanted to point out was that I gave a report to the sentencing judge at the sentencing from the Social Security Administration, and the hearing officer that found him to be eligible for Social Security disability because of a mental disability said that even when he was taking his medication, his insight and judgment were extremely poor. So now you have before you a man who might be on medication and who might have a demeanor of competency before the court. But even Pate said, if there's a demeanor of competency, that doesn't excuse the trial court judge's duty to order a hearing when other factors in the case, for example, all his hospitalizations in mental hospitals, raised a reasonable doubt as to his competency and required a hearing. Let me see what I missed here. I also wanted to mention that the 4th Department did say in People v. Arnold that the United States Supreme Court and this court have not spelled out specific guidelines for the trial court judge to follow when a defendant is brought back from Mid-Hudson. And I would request that this court, using the facts of this case, do spell out some specific guidelines, because it does become an issue every time a defendant appears before the judge. He has to make a decision based on the evidence before him. Do I have to order a hearing on my own motion or not? And I feel that the general guidelines spelled out by the Supreme Court in Drope v. Missouri are not sufficient, that there really should be some more specific guidelines. What in the case triggers this constitutional duty?
You
And I would ask the court to do
represented
that.
the defendant?
Pardon me?
You were actually in court?
Yeah, I was his trial attorney.
All right.
And I have seen him several
Why
times
didn't-
in the prison.
I've read the colloquy, and you requested the court to grant a hearing sua sponte. He said to you in substance, why don't you request a hearing?
Right.
And you said no.
What happened in this case, when reading Christopher case, the same thing happened there. The defendant comes back from Mid-Hudson, and the trial attorney, which I did, I requested on December 13th, I requested a hearing for him. And Mr. Gensler says to the court, I want her fired. I'm no more insane than anyone else in this room. And so I said to the judge, well, in that case, I'm not going to argue with my defendant. I'm asking the court to order a hearing. It has a duty to order a hearing, and I'm asking it to do it. And in Christopher, the same thing happened, and there the trial court judge resolved the issue by ordering the hearing on its own motion, that there's no use in sitting there and arguing with your defendant. If the trial court judge has a duty outside that of the defense attorney, then the trial court judge has to proceed, regardless of what the defense attorney does. And I'd also like to point out that Pate said that this right to a competency hearing is non-waivable.
Thank you very much, Ms. Lee. Mr. Weber?
If it please the court, my name is William Weber. I'm an assistant district attorney for Oneida County, New York, and I'm appearing on behalf of the respondent. I have to say that I disagree with Mrs. Lee in her claim that 730 of the criminal procedure law is not clear on what to do with a defendant when he comes back from Mid-Hudson, or that it's not clear as to when a court must order a hearing. I think it's very clear. The CPL section 730 spells out 3 instances where a court must order a hearing, 3 and only 3. The first instance is when a hearing is requested by the district attorney. That's not present in this case. The second instance is where the hearing is requested by the defendant. That is also not present in this case. Although Mrs. Lee did express some reservations as to whether or not a hearing should be held, she specifically, on the record, on December 15th, accepted the report from Mid-Hudson and did not request a hearing. She expressed some concern that she was doing that because she was afraid that she was going to be fired and would not be allowed to represent the defendant. But that argument doesn't hold much water, because if she had requested a hearing, and if the defendant had said, I'm going to fire you, the court certainly would not have allowed that to occur, because if the very issue before the court is the defendant's competence, then the court obviously would not have accepted the defendant's decision to fire Mrs. Lee. He would have allowed her to request the hearing and would have had the hearing proceed.
Excuse me, before you pass that point, I'm having a little difficulty understanding it. The attorney, after all, represents the client.
That's correct.
Are you saying that against the express direction of the client, the attorney nonetheless should have made an application and persisted in it?
Yes, Your Honor, that's exactly what I'm saying. When the issue before the court is the issue of the defendant's competence, then you can't accept his wishes at that point as to how the matter should proceed. You're the attorney, and you have to make that decision on your own as to how the matter should proceed. If you think, as Mrs. Lee says she thinks, that he is incompetent, then you have to ask for the hearing. She should not have accepted his direction not to have a hearing, and she should not have accepted the statement from him, I'm going to fire you.
Do you believe that an attorney has the authority to act on behalf of a client believed to be incompetent?
At this stage of the proceedings, yes, I believe the attorney does. The very competence of the person is in question, and somebody has to make decisions for him, legal decisions for him, and the person best able to do that is the person's attorney.
Do you think there might be circumstances where it appears or should appear clearly to the court that there's a conflict between the attorney and the client, and where the client will not permit the attorney to request a hearing, but the attorney does request the court to order a hearing sua sponte, when the court should interpret that really as a plea for a hearing?
The court could interpret it that way, but I don't think the court is under any obligation that it has to interpret it that way.
You think it could be interpreted that way here? I mean, wasn't it obvious?
I think that's exactly what Mrs. Lee was trying to do, that she was trying to get the court to order the hearing on its own. But just because that's what she was trying to do doesn't mean the court had to do it. Another option would have been to reassign new counsel. If the attorney was not getting along with Mrs. Lee and was not able to, the two of them were not able to come to a decision.
Would it be an abuse of discretion for the court to not order a hearing in a circumstance where it was fairly obvious that a hearing would be appropriate, but that for whatever reason counsel did not or could not request it?
If that were the circumstances, I would say yes, but I don't think the circumstances in this case indicate that a hearing was appropriate. What the circumstances of this case indicate is that Mrs. Lee thinks a hearing was appropriate. But you have to look at all the circumstances that were present in the case, not just what she thinks was.
Was there sufficient evidence before the court of the defendant's capacity to proceed?
On December 13th and December 15th, there was sufficient evidence before the court for the court to determine that the defendant was competent. The court had just received a report from the Mid-Hudson Psychiatric Center indicating that the defendant was competent. The court had the defendant in front of him and was able to observe him and observe his demeanor. All the other indications Mrs. Lee has been talking about the defendant's incompetence was an incompetence that existed in the past. But although they do have some bearing on the present competence of the defendant, they're not totally controlling. What's controlling would be the most recent report and his appearance in front of the judge on that date and time.
How long in the past?
Prior to the most recent ones finding him incompetent were, I believe, in November of 1981. The report that occurred, no, they were in October, I'm sorry. The report that occurred at Mid-Hudson that was done on November 24th, 1981. The two reports that had found him incompetent were done at the end of October 1981. So they were, the ones that found him incompetent were recent. But when he went to Mid-Hudson, was put on his medications and was examined, he was found that he was competent.
How long was he in Mid-Hudson?
Approximately 2 weeks, I believe. Only about 6 days before he was examined, however. He wasn't there long. In any event, the third circumstance under which a hearing must be ordered is when psychiatric examiners disagree. In this case, the psychiatric examiners never disagreed. And the problem that Silverstein has presented is that it is too broadly interpreting that term. As a matter of fact, if you look at a copy of Silverstein, when they try to quote the statute, they don't even quote it right. They say, they use the term examining psychiatrists instead of psychiatric examiners. And although the terms are similar, they're certainly not identical. Silverstein is using the term examining psychiatrist to mean any psychiatrists who examine the defendant. But that's not what the statute says. CPL Section 730 says when the psychiatric examiners disagree. And the term psychiatric examiners is specifically defined in 730.10 Subdivision 7. And no one else in this case, other than the two doctors in the Oneida County Department of Mental Health, Dr. Rao and Dr. Cotwall, fit that definition. Dr. Weber, the private psychiatrist hired by the defendants, does not fit that definition. Dr. Vandenberg, the psychiatrist at Mid-Hudson, does not fit that definition. Therefore, the psychiatric examiners in this case never disagreed. Therefore, the court was not required to have a hearing. Therefore, none of the three circumstances under which the court must order a hearing are present in this case. All that remains is, did the court abuse its discretion in not ordering a hearing? The court can, in its own discretion, order a hearing. This court has offered some guidance in what standard is to be used when deciding a hearing should be ordered. In the case of McElwain and Armlin, and in the case of People v. Smythe. All these cases give some guidance. Basically, they have to say there has to be some bases or reasonable cause to doubt the defendant's sanity on the date he pled. On the date he pled, December 15th, 1982, all the indications before the court were that he was competent. The most recent psychiatric report indicated he was competent. You can look at the transcripts of the 2 days. You can see that he knew what was going on. He knew who the judge was, the defense attorney was, the prosecutor was. You can see he was participating in plea bargaining on the record. He could distinguish between what count was charging him of what. He demonstrated a good knowledge of what occurred on the date he was accused of committing the crime. All these things before the judge indicated that he was competent. It was not an abuse of discretion for the judge not to order a hearing. Unless there's any questions.
Thank you very much, Mr. Weber.
Thank you.
All please rise. Hear ye, hear ye, hear ye. All persons having any further business before this Court of Appeals, held in and for the State of New York, may depart hence, and appear here next Tuesday afternoon at 2 o'clock, to which time this Court now stands adjourned.